Hello everyone. Welcome to Karmyogi IAS. I welcome you all aspirants to the session of Indian polity, which will be a quick revision session where I am going to discuss one of the very important topics that has been in the news in the past, and that is right to silence. I'll explain you all where is right to silence implicit in our Indian constitution. Side by side, I'm also going to explain you what is the importance of this right to silence and also interlink it with your fundamental rights. Moreover, we'll also discuss some of the Supreme Court judgments, as well as I'm going to tell you the importance of this particular topic and the recent impact it had after the Supreme Court judgment. Let's begin without any delay. First of all, right to silence. Okay. So when we talk about right to silence, where it is inherent, after the recent Supreme Court ruling in the Delhi excise policy case, as well as certain previous cases, we have come to deduce that Article 20 comprises of right to silence of a particular individual. Okay. And within that Article 20, right against self-incrimination was the context in which Supreme Court gave its ruling. Okay. Now, coming to this, recently the Supreme Court has stated in court itself that right to silence is inherent part of Article 20 and our fundamental rights. And the most important thing, investigators cannot force them to speak up or admit guilt, emphasizing that Constitution accords every person right against self-incrimination. That means that in case somebody is arrested, somebody is put into custody, they are not bound to speak or they cannot be forced, whether by torture, with mental or emotional or physical, or the authorities cannot compel them to give certain evidences that can go against themselves. That is why most of the accused who are there in any case, they plead not guilty. Okay. So this has to be known to everyone. Now, what did Supreme Court observe with respect to right to silence? Okay. It said that the Constitution grants the right to remain silent to every individual. And it emphasized that individuals have right against self-incrimination and no one can be forced to be witness against themselves. This is very important for all of you people to understand that nobody can be compelled to be witness against oneself, because then what will be the role of judiciary? What will be the role of whole of the proceedings which are there in the court? If somebody is forced to accept his guilt, okay, there are chances that some of the people who are less resourceful and fighting against more resourceful people, they can be victimized. That is why this right has been guaranteed to us. Again, cooperation does not mean confession. In this relation, I'll tell you that cooperation does not mean confession. Means it is expected of all the accused who are arrested or who are put behind the bars that they will cooperate with the authorities in investigation as well as the trial process. However, that cooperation does not mean that the person will admit the guilt. Means that person will not be forced to admit the guilt or they'll not be forced to give evidences against themselves, right? Then remaining silent cannot be considered non-cooperation, as individuals have the right to choose not to speak. Okay. Third observation is prosecution's burden of proof. Now, suppose somebody is being accused of any particular crime, accused of a particular action of himself. They cannot be forced to like tell and give the burden of proof that I have committed the guilt. They cannot be forced to give the evidences. It is upon the prosecution. Prosecution means the opposite party who is fighting the case against the accused, or the government lawyer or the government advocate who is fighting the case in order to prove that person guilty. Okay. Fourth observation was refusing confession does not limit freedom. The court said that an accused person cannot be deprived of their freedom solely because they have not admitted to alleged crimes. That means if somebody has pleaded not guilty in the court or pleaded not guilty in front of the authorities and are not telling any evidences against themselves, then it cannot be touted that the person or the accused shall be deprived his right to freedom. They cannot be tortured, they cannot be exploited, they cannot be punished for just this reason. Okay. Now there are certain, this was the all observation of the court that I told you, which recently happened in one of the cases. Now, when we talk about right to silence, there are certain constitutional provisions which you people must know. Okay. Article 20 is there. under our fundamental rights. Now, this Article 20, it grants protection against arbitrary and excessive punishment to an accused person, whether that person is citizen or foreigner or a legal person. Means not only citizens or foreigners, but certain legal entities like a company or a corporation or somebody being representing that particular company or corporation, they are also covered under this particular provision. Now, this Article 20 has certain sub clauses. First sub clause is no ex post facto law. That is the first thing. Second is no double jeopardy. And third is no self incrimination. Now, when we talk about no ex post facto law, what does this mean? That no person shall be convicted of any offense except for the violation of law in force at the time of commission of the act. So, let's take an example. Suppose somebody has committed a particular act today for which there is no law in 2024. Suppose somebody committed an act in 2024 for which there was no law in force. Now, suppose in 2026, the government formulates a law on that particular act where a punishment is granted for 7 years or more. Now, can that person be punished for the crime committed in 2024? The answer is no. He cannot be punished for the crime committed in 2024. That is meant by ex post facto law. Okay. And second is no person can be subjected to a penalty greater than that prescribed by law in force at the time of commission of the act. Again, in this particular clause, it is meant that suppose somebody has committed a crime of theft. Okay. Somebody has committed a crime of theft. It comes under IPC 420. Now, if suppose under IPC 420, the punishment is for 4 years or 5 years, whatsoever maybe. Okay. Then that person shall be subjected to 4 years or 5 years of sentence only, not more than that. Means what is prescribed by the law has to be followed in letter and spirit. That is very, very important. So this is the ex post facto law clause. Then we come to the double jeopardy. There should be no double jeopardy. That means if a person has committed a crime, an offense only once, he cannot be subjected to penalty, punishment, or sentence more than once. So suppose any of you or even me has beaten up somebody, then I cannot be subjected to punishment again and again, again and again. That is why many of you must have heard a line in many of the movies that the punishment for one murder is also lifetime imprisonment and the punishment for 10 murders also is lifetime imprisonment. So this is the case. So no double jeopardy means a person cannot be prosecuted or punished for an offense more than once. However, this does not apply to departmental inquiries. That means suppose you are an official, somebody is an IS officer, he has been charged with an offense of corruption or bribery, then he can be punished by law, by the judiciary. Side by side, his department can also initiate an inquiry. That means departmental inquiries are not covered under double jeopardy clause. This is the second clause under Article 20. Coming to the third one, which is very, very important, and in relation to which we were discussing just now, no self-incrimination. That means a person who is accused of an offense, who is accused of an act, cannot be compelled to be witnessed against himself. I again explained you this time, earlier also I explained. That means he cannot be forced to give evidence or forced to confess the crime. Now, this protection is available against both oral evidences and documentary evidences. That means orally also, he is not bound to confess his crime, and he is also not bound to give certain documents, records, evidences against himself in writing or in physical format. Okay, this is there. Now, coming to further things, there are certain exceptions under Article 20. What are the exceptions? Article 20 does not extend to compulsory production of material objects. So suppose somebody is asked in the court to give his signature on certain documents, they have to give it. Similarly, if somebody is asked to produce certain objects or submit certain objects like his materials, his digital devices, his gadgets, they are bound to do that. Then there is compulsion to give thumb impression, signature, blood specimens in order to cooperate with the authorities. Then there is compulsory exhibition of body. Means if the person or the accused in an offense is asked to provide compulsory exhibition of the body, means for medical examination, for getting certain evidences in case of murder or crime, then he is or she is bound to give that. It extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. Now, why this is so? Why only to criminal proceedings and not civil? Because civil proceedings, civil cases like those related to marriage, taxation, property, they cannot be clubbed under self-incrimination because there are certain issues with respect to those proceedings. As in civil cases, the courts are sometimes a bit lenient. And there are chances that in case of civil proceedings, if this self incrimination clause is brought into action, then what will happen? There might be chances that civil cases might be dragged for long. People might not be providing certain documents or false physical material which are required for smooth conduction of proceedings. Okay, so for civil wrongs, it is not there. Now, Article 23 is also there. 20 clause 3. Now, Article 20 clause 3 states that no person accused of any offense shall be compelled to be witness against himself, as I told you. And again, this protection is limited only to criminal cases. So these things should be known to all of you. Okay. Now, there are certain Supreme Court rulings which have been very famous with respect to these cases. You people should be aware of these rulings, not verbatim, but a brief idea will also do. First was the state of Bombay versus Kathi Kalu Ogad, in where the Supreme Court ruled that obtaining photographs, fingerprints, signature, thumb impression would not violate the right against self-incrimination. So this might be asked. Then Ritesh Sinha versus State of UP was there, where Supreme Court broadened the parameters of handwriting samples to include voice samples, adding that this would not violate right against self-incrimination. Then there was Selvi versus State of Karnataka. Here the court held that narco analysis test without the consent of accused would amount to violation of right against self-incrimination. Okay, so these rulings are very, very important. You people should keep a note of it. There are possibilities that UPSC may ask some of the rulings and ask you the context of it. Okay. Now, moving ahead, there are certain exceptions to right to silence. Okay. What are these? It is not absolute. When I say it is not absolute, that means that in cases involving public safety or national securities, authorities may have power to require individuals for giving certain answers or information. So suppose somebody has committed a crime against the state or crime against the nation, or he is a traitor or treachery-based crimes he has committed. Then what will happen? They are needed to provide authorities with accurate information in order to help in investigation of the matter. Okay. Now it is limited only to criminal cases. As I explained you earlier, if a person is being questioned under Custom Act, Foreign Exchange Act, they are not considered accused of an offense. They are not entitled to protection under Article 23. Similarly, under Prevention of Corruption Act also, the accused shall give some of the evidences which are required from him. Also, judiciary may not sympathize with the person remaining silent in suspicious manner. For example, if a person chooses to remain silent, their silence itself may be taken into account as evidence of guilt. There are certain cases where if you are always silent, you are not giving any evidence, you are not telling anything, you are not cooperating with the authority, then court may not sympathize, court may be bound or forced to agree that the person is guilty. Okay. Additionally, if there is strong evidence against an individual, their refusal to answer question may be viewed unfavorably by the court or investigative authorities. So these are some of the exceptions to right to silence, which should be kept a note of, because UPSC is bound to ask questions based on exceptions. So generally, these things has to be taken care of, which is very, very important. So you people should be well aware of what all things we discussed today. Right to silence. Again, I'll just give a summary of what discussions we had. We discussed right to silence, the article related to it. We discussed what was the context of recent ruling of Supreme Court. Again, we discussed some of the constitutional provisions related to Article 20, and within Article 20, what are the subclauses. Then certain famous Supreme Court rulings we discussed, which were there. Then we further moved on to discuss what will be the exceptions of right to silence, as it is not an absolute right. Okay. So with this, we come to end of the session. I'll further take up certain more sessions of polity so that you people are easily revising each and everything, because that is going to help you in the examination. First of all, I'd like to tell you that go and revise about right to silence. Go and read Article 23 from your polity book or polity notes which are there, because there are chances these kind of questions may be asked in the exam. Fundamental rights, is one of the most important and favorite topics of UPSC, where time and again it has been asking questions. Okay. So good luck, all the best, and take care of you.